The Child Care and Protection Act, Section 15, power to take offender into custody. Subsection 1. Any constable may take into custody without warrant any person who A. commits within his view any of the offenses mentioned in the second schedule, B. has committed, or whom he has reason to believe to have committed any such offense, if the constable has reasonable ground for believing that such person will abscond, or if the constable does not know and cannot ascertain that person's name and address. So in those cases, they can arrest that person, take them into custody. Subsection 2. Where under the powers conferred by this section, a constable arrests any person without warrant, the officer or sub-officer of the police in charge of the station to which that person is brought shall grant the person bail in accordance with the Bail Act, unless he believes on reasonable grounds that the release of that person on bail would tend to defeat the ends of justice, or to cause injury or danger to the child against whom the offense is alleged to have been committed. So after them arrest the person, if they believe that the person will hurt the child, then they will deny, the judge will deny bail to the person. Section 16. Mode of charging offenses and limitation of time. Subsection 1. Where a person is charged with committing any of the offenses mentioned in the second schedule in respect of 2 or more children, the same information or summons may charge the offense in respect of all or any of them, but the person charged shall not, if he is summarily convicted, that means he's convicted on the spot in the court, shall be liable to a separate penalty in respect of each, shall not be liable to a separate penalty in respect of each child, except upon separate information. Subsection 2. The same information or summons may also charge any person as having the custody care, charge or care, alternately or together, or may charge him with A. the offense of assault, ill treatment, neglect, abandonment, or exposure, together or separately. That will be separately for each child. And B. committing all or any of those offenses in a manner likely to cause unnecessary suffering or injury to health, alternatively or together. But when those offenses are charged together, the person charged shall not, if he is summarily convicted, be liable to a separate penalty for each. So it will be one penalty for all the children at once. Subsection 3. Where a person is charged with any offense mentioned in the second schedule, and the offense is a continuous offense, it shall not be necessary to specify in the information, summons, or indictment the date of the act constituting the offense. So, if it is continuous, then you don't necessarily the date of the act of the offense, the date on which they were committed, would not be necessary. Well, continuous offense, that is another situation. Maybe placing them under a certain living condition would be a continuous offense, but physically beating them in an abusive manner, beating them would not be a continuous offense, and the date of the beating or other abuse would be entered in the books. All right. Section 17. Power to hear the case in absence of child. Where in any proceedings with relation to any of the offenses mentioned in the second schedule, the court is satisfied that the attendance before it of any child in respect of whom the offense is alleged to have been committed is not essential to the just hearing of the case. The case may be proceeded with and determined in the absence of the child. So if the child's presence is not really needed, then the case can continue. Section 18. Extension of power to take settlement of child, or to take statement of child, Subsection 1. Where a justice of the peace is satisfied by the statement of a duly qualified medical practitioner that the attendance before a court of any child in respect of whom any offense of the offenses mentioned in the second schedule is alleged to have been committed would involve serious danger to the life or health of the child, the justice of the peace may take in writing the deposition of the child on oath, and shall thereupon subscribe the statement and add thereto a declaration of his reason for taking it, and of the date on which and the place where it was taken, and the names of the persons or if any, present at the taking thereof. All right? That's a deposition of the child on oath, because they're not going to be able to be present in court. Subsection 2. The justice of the peace, taking any such statement, shall transmit it with the justice's declaration. A. If the statement relates to an offense for which any accused person is already committed for trial, to the proper officer of the court for a trial at which the accused person has been committed. Let me read that again. The justice of the peace, taking any such statement, shall transmit it with the justice's declaration. So the justice of the peace is declaring. A. If the statement relates to an offense for which any accused person is already committed for trial, to the proper officer of the court for trial at which the accused person has been committed. Okay, so I guess they're already charged with an offense, that same offense. So the justice of the peace must take it to the court where the person will be tried. B. In any other case, to the clerk of the court before which proceedings are pending in respect of the offense. Right. Section 19. Admission in evidence of deposition of child. We will look at this in a different video.